set forth our appearances. We'll start first with the plaintiff, and we'll move to the defense. We're going to look at the plaintiff.
Good morning, Your Honor. Katie Parker on behalf of the plaintiff.
Good morning, Your Honor. Robert Eglin and Maggie Federico, plaintiff.
Good morning, Your Honor. Brianna Sitza.
Good morning, Your Honor. Eric Peppermint, the plaintiffs.
Brett Johnson, Tyler Watson, Mike Esposito, and Eric Freeman on behalf of the plaintiffs. Morning, Your Honor.
All right. Good morning, sir. And good morning, everyone. And let's go ahead and get started. I know we have two motions. We have one supplementation to the record, and then we have another motion regarding a prior motion to eliminate and its impact. That would be plaintiff's motion to eliminate number 16. That's my recollection.
Yes, Your Honor. And is it okay to start with the King's motion?
It's fine.
Okay, so this is plaintiff Lisa King's trial brief regarding plaintiff's right to present ongoing medical treatment and future care recommendations. Defendants have been on notice of Ms. King's ongoing treatment for myasthenia gravis, MG, throughout this action, Your Honor. Since May 21st, 2019, Ms. King has been under the care of Dr. Mahajan, her neurologist for MG. And recently, Ms. King was hospitalized for an MG flare-up at Centennial Hills Hospital from February 14th through February 16th of this year. And she received 3 IVIG infusions during that stay. 2 days after February 18, 2015, Ms. King promptly supplemented her NRCP 16.1 disclosures and pretrial disclosures with the medical records from Centennial Hills Hospital, and billing was supplemented as soon as it was available on February 27, 2025. On February 27th of this year, King had a follow-up appointment with Dr. Mahajan. Later that day, same day, I was informed that Dr. Mahajan had decided to change the frequency of her IVIG treatments to better control her systems. He had originally prescribed her to have these once a month, and she started out doing that, and then she didn't want to do it anymore. It was difficult for her, so she stopped, and then they were just doing it when she would have a flare-up. And apparently Dr. Mahajan has insisted to better control her symptoms, that she have these once a month as opposed to just when she has a flare-up, because it causes too many wide swings in her systems, and he's concerned, he's concerned about her dying, quite frankly, if she keeps that up. So I arranged for a telephone conference with Dr. Mahajan for 7 a.m. the next morning. During that telephone conference, he confirmed he was placing Lisa on monthly IVIG treatment schedule to better control her symptoms. Following the phone conference, I contacted Ms. King's life care expert, Bruce Hirschfeld, and asked him to confirm this with Dr. Mahajan. And then my office immediately requested the medical records from Dr. Mahajan's office for the February 27th visit. However, when I received the record, it did not indicate the change to regular monthly IVI treatments within the record. But it was also not authored by Dr. Mahajan, but rather his nurse practitioner, Andrew Violin. I met with Dr. Hirschfeld the next day, Saturday, in my office at 3 p.m., which was March 1st. And during that meeting, I learned that Dr. Mahajan saw King after his nurse practitioner saw her on Thursday morning and informed King of this change in her future treatment plan. And so based on this recent treatment and updated treatment plan, King's expert witnesses, Dr. Hirschfeld and Stan Smith, will be supplementing reports. I talked to Dr. Hirschfeld this morning, and I expect to have his supplemental report by the end of the day, and I will immediately email it to defense counsel, as soon as I got it, and then I will be sending it to Dr. Smith immediately for him to do an updated report on his economic evaluation. So due to scheduling conflicts on March 1st, I was unable to prepare the instant brief for the court until the next day, which was Sunday, because I was at a event for BA Shiro, which is an organization that my wife and I are involved in. In fact, we're their legal counsel regarding child sex trafficking here in Nevada. So I didn't get a chance to write the motion or the trial brief until Sunday. We immediately served defense counsel and filed it and served the court, Your Honor. Lisa's medical conditions and treatment do not exist in a vacuum. Her medical problems are ongoing, and she has been forced to seek continued treatment with her physicians. Injured plaintiffs are not required to cease all ongoing medical treatment between the close of discovery and trial. In many instances, and this is one of them, injuries dictate continued treatment for the rest of the plaintiff's life. And Ms. King's MG has required ongoing treatment, as well as her autoimmune hepatitis, including hospitalization, IVG transfusions, medical evaluations, and routine laboratory testing. It would be prejudicial and blatantly misleading to the jury if her treating physicians and expert witnesses were precluded from offering opinions as to the present and future state of her medical care. An update to medical records and future care recommendations based on recent treatment is not an untimely disclosure. NRCP 16.1A1E states that a party must make its initial disclosures based on the information then reasonably available. Similarly, the rules require parties to supplement their disclosures in a timely manner if they learn that the information previously disclosed is incomplete under NRCP 26E1. Ms. King in my office has complied with these obligations to the letter. The supplement only became necessary when she was admitted to the hospital 2 weeks ago for an MG flare-up, and once the records were obtained, NRCP 16.1 disclosures and pretrial disclosures were supplemented. Medical billing was supplemented as soon as it was available to us. An increase in damages due to new treatment is not a discovery violation. The key requirement is the timely disclosure. This could have not been more timely than the way we handled it professionally, Your Honor, with respect to the updated information once it became available. Because the new costs were disclosed as soon as they became known, there is no basis for exclusion here. Defendants were on notice that plaintiff's expert may supplement their opinions based upon ongoing treatment as they provided such reservations in their respective reports and within their expert designations. See NRCP 26E2. And Ms. King should be entitled to present evidence of her ongoing medical care, including the cost of treatment through trial and evidence pertaining to her future medical needs that have changed. Lisa's updated medicals need to be directly related to the injury, are directly related to the injuries at issue in this trial, and the defense retains an opportunity to cross-examine the treating physician and medical experts, as well as have their experts supplement their reports when I provide them with mine. Like I said, I will have Dr. Hirschfeld's do them by early this evening. And I'm going to immediately send his report to Dr. Smith and tell him he's got to do this immediately, and I hope to have it within a couple of days. Neither Dr. Hirschfeld nor Dr. Smith will be testifying until next week, Your Honor. Exclusion would unfairly penalize Ms. King for a medical development outside her control and deprive the jury of relevant necessary evidence in determining the full extent of her damages. And so the court should permit introduction of this highly relevant and probative medical evidence while allowing the defense reasonable procedural accommodations, which I agree they should have, with their experts being able to supplement their reports as well, Your Honor. Thank you.
Thank you. And let's hear from the opposing side. Sir?
Thank you, Your Honor. Introducing records and having Ms. King testify regarding recent treatment and a flare-up in infusion therapy is one thing, but for having experts days away from testifying change their reports and opinions, and that just goes too far, and that's very prejudicial to the defendants at this late hour. These experts haven't seen her, they haven't treated her, so having her testify or her treating physician testify is one thing, but completely changing expert opinions and disclosing that at this late hour is far too prejudicial.
Here's my question as far as changing of opinions. Isn't it really an issue regarding changing of the current medical condition?
It's the frequency of treatments is all.
Yeah, but that's kind of what I mean.
Yeah.
It's just a change in her medical condition. There's no new opinions, are there?
Well, we don't know. We just got this brief and information about she hadn't had any infusion since November of 2023, and now all of a sudden last week she goes back and has it again. It's a significant change, in my opinion. And like I said, introducing records and having her testify regarding her condition is one thing, but having multiple experts issue new reports that you don't even have in the days away from testifying.
But here's my question on that. I mean, you can't testify as to her change of condition unless there's medical experts to support that, right?
But and her treating physician would be able to testify about that. They don't need to go and change all the expert reports. It doesn't unfairly penalize her because she has claims of ongoing and future treatment needs. And so that's part of her claim. You don't need to have experts, issue new reports and change their opinions days away from testifying. That's where it goes too far. Obviously, there's claims of, she needs treatment in the future, and the experts have opined about that. But now, we're sitting here waiting for reports.
But what if there's a change in the, like Mr. Eglin said, the frequency of treatments or different types of treatments?
Well, that's the uncertainty of future treatment, and that's what these experts had.
No. Typically, pursuant to the Rule 16 process, unless there's a change, you know what the game is going to be. You know what the issues are going to be regarding future treatment, necessity, and all those things. But I'm trying to figure out, and here's my point, and I think this is a really important point. What standard are you suggesting that I follow as it pertains to the supplement based upon allegations of change in medical condition or treatment? Because at the end of the day, the rules aren't self-executing. They're not. And here's my point. Don't I have to conduct some sort of analysis? Shouldn't I be tethered to a rule if I'm going to make a determination such as that?
Well, that's the thing here. She just had this appointment. The doctor had a recommendation to alter her treatment schedule. And apparently that will go into effect at some point. And how long is that going to go for? They don't know. I mean, it's been over
Life.
14 months since.
Life. That's
Mr. Eglin, I know you're going to tell me what you're going to tell me. I know that. But I just want to make sure counsel finishes.
Yeah, again, she hasn't had treatment in over 14 months, and all of a sudden there's been a change recommended a couple days ago. Having her or her treating physician testify about that is one thing, but having multiple experts who don't treat her or see her change opinions and issue reports days away from testifying just goes too far and it's too prejudicial. She's not penalized because she's going to be testifying and her doctor can testify about future treatment and
Did her treating
recommendations.
physician do a life care plan?
No, you do not.
Her treating physician talked about her recent treatment and
But my question is this, did the treating physician do a life care plan?
no, that's an expert,
Right. Okay.
Your Honor, that's unclear. I don't know if Hirschfield's a treating expert or not.
He's not.
But I mean, my question is this, you said we should limit it to her treating physician. If the treating physician didn't do a life care plan, potentially, are we missing something regarding her future diagnosis and care?
That's why you have expert deadlines. You've already opined on what they believe a future treatment is gonna need. Because there was a recent change, we don't know how long that change is gonna last. I mean, they make estimates on future care, they submitted reports, the deadline passed, and now we're sitting here in trial and, a new report is gonna come out, and then they're gonna be testifying in a few days.
But I want to circle back, what standard should I apply?
I would say the discovery deadline is there for a reason. You have reports, they have to, just like you ruled with Dr. Gupta, you know, there's a deadline, you have an expert report, you have discovery, there's a discovery deadline. At some point,
I get that, but that's why I was very clear in this perspective. Are you saying that the rules are self-executing? There's no standards that trial court should look at, like under Rule 16, there's a good cause standard, and I conduct a good cause analysis. This appears to me potentially might be a 37B1 issue. Under those circumstances, I make a decision as to whether there's substantial justification and or the supplement is harmless. And ultimately, I have to make those types of decisions, right? Because at the end of the day, a reviewing court's going to want to say, well, look, Judge, if you let it in, why? What did you rely on?
well, and that's why I proposed what I did, is that, you know, we know about ongoing and future treatment. She in fact had that, a couple weeks ago, and, you know, that is a fluid issue, and so I would think, you know, that would be something that would be allowed in. But to go back and say, okay, well, we gotta go back to the drawing board, let's have our experts issue new reports, I mean, you know, I think it would be ridiculous to open up discovery again.
No, you answer my question, what standard should I apply? Right, I mean, because I do have to make a determination based upon the rules. And it's not just what I want to do or what I think is right or wrong. At the end of the day, I'm gonna have to make a determination whether there's good cause for the supplement, whether there's substantial justification, whether it's harmless. I mean, that's what I have to do.
Your Honor, our position.
Wait, how, are we gonna have two people on this side arguing the same motion? We're not doing that.
They've been doing that. They've been doing this.
Can you keep it very short, very short? Just what do you want to add, and I'll go back.
There's no justification for it because counsel already admitted that this was a possibility on her treatment, that she was going to be treated once a month. That could have been put into the report. This is an alternative. If it doesn't work, we won't do it quarterly, we won't do it when she wants to do it, we can do it once a month as we did before. What this ultimately does, since they already knew it, this puts us in a position of having to change two expert reports. Future care and the life care plan and the economic experts. And for that reason, it's prejudicial, untimely, and could have been foreseen easily based on our own papers. Thank you.
Anything else you may answer? Because I take notes and I listen. So we've gone from possibility to probability to potentially a certainty based upon the new medical.
I don't have any further, thank you, Your Honor.
Your Honor, I'm not a doctor to suggest that I somehow am some crystal ball in medicine and I know that her neurologist is going to change her recommended treatment plan. How am I supposed to know that? And that's ridiculous. There's no admission that I knew this was going to happen or even possibly could happen. I was as surprised as everybody else. And they're right, she hadn't had an IVIG treatment since I believe November of 2023, so whatever that is, 13 months or so. Because she was not doing them quarterly like they had been recommended, and she was doing it when she had a flare-up. But Dr. Mahajan is concerned that she will not get to the office, the hospital in time, and the way her throat closes up from her MG, she could die, she could suffocate. So he has indicated this is absolutely necessary not only to keep her symptoms from these rapid, huge swings that she has to undergo to a more level. She can still have the symptoms, but not maybe as severe. I don't know. I haven't asked Dr. Mahajan that. But the point is, he's concerned she is going to die if she doesn't have these monthlies. And the answer is, it's for the rest of her life. That's what he has told us. And, you know, the only prejudice here will be to Miss King, that she can't put on what her actual damages are in this case, to no fault of her own. And finally, Judge, counsel didn't even mention and ignores all the Supreme Court cases I cited on this. Yamaha Motor versus USA, or Company USA versus Arnold. 1998, Nevada Supreme Court case. Golden Nugget, Las Vegas Corporation versus Service Control Corporation. 1995, Nevada Supreme Court case. O'Connell versus Wynn Las Vegas, Nevada Supreme Court case from 2016. Carol Ferrisic Revolta v. A. Champagne Company, LC. 2021 Nevada Supreme Court case. Washoe County Board of School District versus Perala. 1968 Nevada Supreme Court case. Pizarro Ortega versus Curvadas Lopez. 2017 Nevada Supreme Court case. All of those cases say what is going on here is not inappropriate. It is not a change in opinion. It's a change in the frequency of her IVIG treatments. And yes, the life care planner has to account for that because he has in her life care plan the IVIG treatments quarterly. Now they're monthly. And they were quarterly for life, so they knew these were for life. Now they're monthly for life, Your Honor. So she will be deprived of being able to seek her entire all of her damages from this jury if this is not permitted. And we followed the requirements for notice to the letter of the law here, Your Honor. Thank you.
Here's my question, Mr. President, for you. What standard should I apply?
I think you should apply the standards that's set forth in those Supreme Court cases, but also I believe that if you look at NRCP 16.1 and Rule 26, those standards apply here, Your Honor.
Well, the reason why I say that is this, because at the end of the day, whatever decision I make has to be tethered to Nevada rules of procedure. And for example, as far as exclusion of evidence, the rules aren't self-executing. They're not. And typically, when there's a motion to exclude, it might be based upon Rule 37, B1, right? Then I have to conduct a substantial justification, and a harmless type analysis, maybe a good cause analysis, depending on if it's under Rule 16 or not. That's kind of the point. Anything else from anyone on this issue? All right. And for the record, was there an opposition filed? Do you know? I just want to make sure.
I don't think so. We just filed a brief Sunday, so.
I understand. What's today?
Tuesday, Your Honor.
All right. It'll be Friday. Anyway, if you take a look at the rules, and one thing that happens in cases involving significant bodily injury, you do have changes in the medical condition of the claimant. And so from the fundamental fairness perspective, I'm going to permit the supplementation. But just as important too, I want any reports submitted to the defense ASAP. And I want to give them a full and fair opportunity to have their experts prepare reports that address that specific issue, any changes. And just as important.
The only reports that are to be supplemented, Your Honor, are the life care plan and the economic evaluation taken to present value.
But I want that. And just as important too, the medical records from the doctor regarding the hospital.
They've all been supplemented, Your Honor. They've received them.
And when do you think you can get that to them? Any idea?
Pardon me?
As far as timing is concerned?
I believe I will have Dr. Hirschfeld's supplemental life care plan to them by early this evening, not long after court's done. I have to go back and look at it. I'm hoping it's there when I get back. I told him today that I need it when I get back from court today after 5. And I will be immediately sending that to Dr. Smith, who I'm going to ask to try to get his turned around within 48 hours at the most.
All right. And assuming today's Tuesday, do you think there's a good probability all reports will be in the hands of the defense by Thursday or Friday?
Yes, Your Honor.
Okay.
By Thursday, I think.
Thursday. And from a defense perspective, 10 days, is that enough time to do your calendar?
We may be done with trial by then.
Yeah, I was gonna say.
I'm not as,
Optimistic?
yes.
Well, I believe we have.
I'm fine if I get the reports the day before they testify, is my argument, Your Honor.
Yeah, because we tentatively have Keddington testifying on the 14th, so I would say that,
That's 10 days from now.
yeah, so the 13th.
So if I could have it the day before, the morning before, that's fine.
Okay.
There you go. Prepare the appropriate one.
And their economist didn't give any numbers, he just gave criticisms of Dr. Smith's evaluations or his methodology, I think, so he's never given any numbers, so.
For Sims, we're having Sims testify on the 17th, so we'll get that to him on Friday before.
Thank you.
Let's move on to the next issue.
Just one other issue before Mr. Kemp argues on his motion, Your Honor, in council, is that we sent over in 2 separate emails the order granting, the court's granting our pre-admission plaintiff's exhibits, and we never heard anything back, and so we submitted the order to you on Saturday over the weekend, and I was wondering if you had a chance to sign it, if you can get it signed today.
We'll take it.
Okay, thank you.
Can I clarify something?
Yes, you can.
So, the reports are to be in the hands of the defense by Thursday, and the defense is to respond by the day before testimony. Am I correct?
That's fine, yeah.
Okay.
Thank you. Let's move on to the next issue.
Thank you, Your Honor.
And for the record, let's identify the motion, just to make sure we're not.
Sure, Your Honor, this is Real Water Defendant's trial brief to exclude plaintiff's expert Catherine Hutt. And this trial brief arose shortly after the court entered the order on motion in limine 16, amongst others. And in that motion in limine, as the court is aware, the court not only ruled that violations of or compliance with state and federal regulations were inapplicable or irrelevant to the issues of compensatory and punitive damages, but in that order, the court adopted all of the findings and reasoning that the plaintiffs included in their motion. So, Your Honor, this is, as far as we're concerned, a law of the case doctrine issue. Now, Your Honor is aware, as recently as 2024.
And explain to me how that is, and the reason why I'm asking you this, and tell me if I'm wrong or not, but what specifically the motion in limine number 16 does?
Motion in limine number 16, Your Honor, according to the plaintiff's own moving papers, asked the court to determine, and let me get to the appropriate language here, that federal standards and regulations are wholly irrelevant to the safety of the product. Plaintiffs further argued, and this is on page 3 of the trial brief, Your Honor, that violations of law or regulations are neither required for the imposition of punitive damages nor relevant to the plaintiff's punitive damages claim. At the hearing on this issue,
And I
counsel...
have a question, I don't want to get you off track,
Sure.
because it's my recollection that at the end of the day, this case involved, because I've had 2 go to trial, I don't mind telling you that.
Understood.
The issue basically dealt with whether or not the defendants had a quality assurance program in effect, right? And that's what the whole issue's about. And here's my point. This gets often overlooked. When it comes to issues of strict products liability, the reason why I said it that way, because I think we overlook sometimes that it really is a different tort concept. We're talking about strict products liability. And the whole basis as far as strict products liability under the restatement of torts, section 402A, is a defective product and will be dangerous. Close one. And so the sole thrust and focus is on the product itself and not the conduct of the party or the defendant. And here's my point. whether there was FDA appliance or not, that really doesn't matter when it comes to the ultimate determination by the fact finder as to whether or not the product is defective under the restatement of torts 402A. And so conduct in that regard doesn't matter. But go ahead, I want to listen to you.
Well, Your Honor, you just made my point, candidly. The court did determine that exact thing during the motions for summary judgment. The court determined that pursuant to 405A, pursuant to, excuse me, my apologies, Your Honor, you're absolutely right. Pursuant to Kraus.
Wait, but here's my point. Conduct is never an issue when it comes to street products liability. However, what impact does that have on punitive damage?
Well, Your Honor, that was exactly what we argued about during the motion to eliminate 16, and I've actually provided the court as an exhibit to the trial brief the entirety of the argument at that particular hearing because I think it's highly relevant here. Excuse me, Your Honor, a little bit of a cough still.
If you have, which one was it? I want to make sure, because I have so many things that can supplement.
Right. Your Honor, if I can approach and see what you have with your.
Oh, I don't know, you can approach.
I know we provided you with a copy. Oh, here you go.
Thank you.
Pardon my reach.
All right, you notice it's been read as tab.
Your Honor, one thing I've known with this court is the court is always well-read and well-prepared for the hearings. So, Your Honor, with regards to this particular issue, this was already argued, this was already decided by the court. That's why I'm saying this is a law of the case issue. We
But the
argued,
reason why, but think about it for a second. I'm glad you brought that up because here's my point. You say law of the case issue. How can you have a law of the case issue when it deals specifically with motions in limine, which are interlocutory in nature?
correct, Your
By
Honor.
their, I mean, that's different than a summary judgment.
And Your Honor, funny enough, I thought you might mention that. So, if the court would direct its attention to the Nevada Supreme Court decision in Litchfield versus Tucson Ridge, that's 140 Nevada Advanced Opinion 57. Not only does the court address the standards for applying law of the case, the court applies the standards for deviating from law of the case, and none of those standards apply here. But most importantly, for that particular question, the Nevada Supreme Court expressly states that the law of the case applies to interlocutory orders unless one of those rare exceptions apply. Because it would be deemed reconsideration, it would be exceptionally prejudicial to the party that is relying on the court's interlocutory order. So under Nevada Supreme Court mandatory authority, interlocutory orders are subject to the law of the case doctrine, which has been expressly adopted in Nevada. So I hope that answers the court's question on interlocutory
And
orders.
where is that? I just want to take this quick look here.
140.
No, was that supplied or?
No, Your Honor, that is not cited in the moving papers. That is simply a statement of the the legal standard that is being applied in Nevada as the law of the case.
All right, I understand.
There are references in the motions to the plaintiffs being stopped from arguing to the contrary of what they've argued in the past, follows its line, but I think the case law, anticipating the court's concern,
And what's the site again?
140, Nevada Advanced Opinion, or ADV OP 57. And Your Honor, if you don't mind me grabbing my phone for a second, I have it up on there, I can actually provide, I might be able to provide you with a pin site.
No, that's okay.
Okay. And Your Honor, in there, they do discuss exceptions that were provided in a case called Sue, HSU. Arguably, none of those apply. So, Your Honor, getting back to it, if we're looking at this through the lens of the law of the case doctrine, or even simply applying the standards that this court just discussed today, the fact remains that the plaintiffs have taken the position, and the court has adopted the position, that once liability and causation has been established, any compliance with FDA regulations, or, to quote Counselor Peppermint for the plaintiffs, any violations of state or federal regulations are irrelevant.
Now, here's my question, I don't want to cut you off, but what state or federal regulations are you talking about?
You know what? I anticipated that too, Your Honor. Let's go through them.
And do they apply to water?
Yes, well, Your Honor, let's start with, let's go with 21 CFR 165-110. This is the federal regulation through the FDA governing bottled water as adopted pursuant to FDA final rule entered May 29, 2009. Now, this particular regulation also relies upon 21 CFR 117. Now, funny enough, Your Honor, plaintiffs included reference to CFR 117, or Part 117, excuse me, in their motion in limine. So while they're telling the court that these federal regulations are irrelevant, which the court adopted, as to damages, they point to this very specific regulation. Now, Your Honor, subpart B of this particular regulation is current good manufacturing practices. Subpart C, hazard analysis and risk-based preventative controls. These sections also talk about qualified individuals, which speaks directly to whether or not Real Water had a qualified individual, senior leadership that had the knowledge, training, or experience to properly conduct a hazard analysis or to implement preventative controls. In the trial brief, we've presented all of Ms. Hutt's opinions as they've been provided to us. Every single opinion relies in part or in full on 21 Part 117. And Your Honor, this is especially important. Ms. Hutt actually goes on to state that Clark County has adopted the similar regulations. And I would direct your attention to the Nevada Administrative Code 445A.544, and then at sequitur, because we have in Clark County 445A.552, standards for bottled water, chemical and organic substances. This is where, similar to FDA regulations, Clark County talks about which inorganic chemicals need to be tested for by bottled water companies. We also have 445A.555. This is the determining standard in Clark County for what analysis on samples needs to be done by bottled water companies. We also have, for the record, NEC 445-557.
Thank you.
And then as far as doing the key site on that, Your Honor, this is a 2024 opinion.
No, I see that.
Just if that helps. So, Your Honor, NEC 445A.557 discusses treatment and sampling of water before bottling, and specifically discusses which samples of water must be taken to the plant after water is treated and before it is bottled, and that water must be approved. The methods used to analyze the water must be approved by the appropriate health authority. These are directly on point with Ms. Hutt's opinions. This is exactly what the plaintiffs moved to exclude in motion in limine 16. Similarly, if we get into handling of customer complaints, senior leadership training, education, having a certified HACCP person, NEC 445A.5835 directly discusses requirements for training of employees. And if that wasn't enough, Your Honor, getting back to the federal regulations at issue, that once again are cited in motion in limine 16 as being irrelevant to this issue, we have a definition of qualified individual. That senior leadership that Ms. Hutt is so critical of comes directly from standards or definitions set in 21 CFR Part 117. So, Your Honor, as we go through this, we have, and I'm quoting here, let me get to the right
Are
things.
they basing the punitive damage claims on the regulations you're relating to? Because I did go back and take a look at the, I think it was the reply to the motion. Yeah, it was the reply, and looking at page 5. They say, in this case, plaintiff's punitive damage claim is based on 4 different prongs concerning Real Water's conduct. And that's why I always brought up the distinction with conduct versus strict products liability. They're much different issues. But they're saying that based upon, because I remember this was a real big issue with prior to trials, lack of quality assurance, product complaints, and investigations, testing, and lack of recall.
So, Your Honor, I argued that point during the motions of the main hearing. And I specifically asked this court to consider whether or not the conduct of the parties in complying with FDA regulations, Southern Nevada Health District rules, Nevada administrative codes, was relevant to the question of whether or not punitive damages should be awarded, and if so, how much. Plaintiffs got up and specifically argued that violations, and this is in their moving papers, violations of these rules are irrelevant to the issue of punitive damages. There's an entire section, as a matter of fact, the entire authority I rely upon in the trial brief, Your Honor, is from that motion.
Yeah, but here's my question, though. I'm just answering the question in this regard. Quality assurance.
Sure. Let's go to quality assurance, Your Honor. Quality assurance, according to Ms. Hutt,
Judge, can I make one suggestion before we go too far?
Yeah.
My opening continuation will probably go 50 minutes. So the defense, whether intentionally or not, has taken up so much time that there's no way for me to finish my opening before lunch. So what I would suggest is that we bring the jury in, send them to an early lunch, like 11:30, bring them back at 12:30, 12:45, and then start doing the openings. Because otherwise, we're just gonna go another 30 minutes and, you know, we're gonna result in the same place anyway. I think it'd just be a little more efficient.
Your Honor, I'm getting very exacerbated with the ad hominem attacks that are built into plaintiff's counsel's arguments. I am not intentionally delaying trial.
I didn't look at it that way at all.
I said intentionally or otherwise.
Yeah, no,
Or otherwise.
no, I looked at it this way. What makes sense?
You know, that's the court's discretion, Your Honor. I'm happy to do whatever the court believes is appropriate.
Because he's not saying stop. Your argument, maybe we should let the jury go earlier and come back earlier. That's all.
And, Your Honor, we'd be perfectly fine with that.
Yeah, but you
Again,
just said, I mean, really.
yeah, Your Honor, whatever the court deems to be best to get this trial, to continue moving this trial along in a fair and, you know, equitable manner, I think is what we'd be free to.
Do you want to let Marshall Sloan tell them to just come back here and say 12:30?
I'll think about that real quick, but, no problem with that, right?
No, not at all.
Okay. How long have you been out there, Mr. Sloan?
Your Honor, I have been back in the jury deliberation room where they're a little bit more comfortable.
Oh, okay.
And they've been back there for a good 45 minutes, Your Honor.
How much longer do you think we have?
You know what, Your Honor, I think I need to answer your question and then I concede.
Okay. Well, I don't want you to rush. I mean, efficiency, but not rush.
Sure. Absolutely. Would Your Honor like me to keep going?
Yeah, I'm gonna let you keep going. I'm just thinking about a good time to end it, come back.
Sure. So, Your Honor, I actually highlighted the section on the punitive damages language that you've brought to my attention.
12:40, Your Honor.
Yes. What? 12:40. Excuse me. Is that a good time? 12:40?
We were just suggest 12:45, but that's fine, Your Honor.
Okay, 12:45. That's
12:45, Your Honor.
5 minutes. Okay. Continue on, sir.
Sure. So, Your Honor, the start of Mr. Peppermint's comments on page 151 of the transcript, Your Honor is referencing here, says, as to punitive damages, it's also not relevant. It then says compliance with what?
And that's what I was gonna ask. What are we talking about compliance with?
Well, we're talking about compliance with CFR Part 117 for starters, Your Honor, because when they reference the quality assurance plan, when they reference HACCP, and this is in our trial brief, Ms. Hutt clarifies that this is all federally regulated information. Her entire reliance on her opinion is based on the codification of HACCP in these federal regulations. For example, she goes specifically in one opinion into a food safety plan. That's Part 117, 126. She's critical of the conducted hazard analysis, which is one of the prongs listed by Mr. Peppermint in the transcript. That's section 117.130. She's critical of preventative controls that should have been put into place and were not, according to her. Preventive controls under this plan, under a quality assurance plan and the failure to investigate products, that falls under preventative controls, Your Honor, and I can actually cite, because it says under 117.135, you must identify and implement preventative controls to provide assurances that any hazards requiring a preventative control will be significantly minimized or prevented, and it goes on from there. And then, Your Honor, as far as it goes with customer complaints, that's also codified as a federal regulation. 117.150 speaks to corrective actions and corrections. It requires a corrective action procedure that must describe steps to be taken to ensure that, and I'm quoting, subsection 2, subsection I, appropriate action is taken to identify and correct a problem that has occurred with implementation of a preventative control. So what the federal regulations state is every single opinion that Catherine Hutt has. It is exactly what the plaintiffs have argued is irrelevant here. And candidly, Your Honor, we know this because they cited to Part 117 in their motion. They pulled Catherine Hutt's testimony, pointed to 117, and said, Your Honor, compliance with these state federal regulations is irrelevant to damages. Now, at that time, Your Honor, there wasn't a motion because guess what? The court had not ruled on whether or not liability was established and whether or not causation was established as a matter of law. Under those circumstances, if we're talking about whether or not there was an adulterated product, that's also contained in the regulations. Ms. Hutt can say, if these hadn't been established, that adulterated products or the production of adulterated products violates these regulations, and that goes to liability. But liability has been established. Causation has been established. And Your Honor, and I've flagged these, every single thing that's discussed in the transcript for motion in limine 16, every single opinion that is in the report appended at Exhibit A3 to the trial brief, every single statement or opinion that was provided in the Brown litigation all comes back to these regulations that this court has already said, and I'm quoting the plaintiffs here, are irrelevant to punitive damages. They are irrelevant to compensatory damages. And we're not just talking valuation, we're talking whether or not punitive damages should be awarded in the first place. So at this point, Your Honor, if that's the court's position, and it is,
I don't have a position,
well, you've made a ruling, Your Honor.
but it's not a position.
My apologies for the language, Your Honor. Let me rephrase. Pursuant to this court's ruling,
That's fine.
and Your Honor, I don't want to imply that this court has been anything but
No.
fair in applying the law.
No. Every time a lawyer in this courtroom says position, what do I get?
Correct, Your Honor.
I give the same exact response. I don't, because I don't have a position.
No, Your Honor, I've been in front of you many times. I don't want to imply anything.
No, we can move on from that. It's fine, I don't have a position. This is Litchfield versus Tucson Ridge case applied, because this case involved decisions made by subsequent judges, right? I guess the first one was Judge Peterson, the second was Judge Crockett, or something like that.
And Your Honor, commonly law of the case doctrine does come into play when a new judge takes over a case and decides that maybe the prior judge's opinions weren't in line with their own. But Litchfield provides the broader analysis for the rule. Litchfield doesn't say that this analysis is limited solely when there's a second judge. And frankly, Your Honor, there's an entire progeny of case law in Nevada that speaks to this particular doctrine. And it applies to prior decisions of the court, regardless of who the sitting judge is. The court is bound by its interlocutory orders unless it changes them. Now, nobody here has sought reconsideration. Nobody here is doing anything other than asking the court to fairly apply its ruling.
I understand the distinction you're making right now.
Thank you, Your Honor.
I get that.
So, Your Honor, under Litchfield, which is mandatory law in Nevada, law of the case says we're going to have to apply the same standards under motion in limine 16 that we previously did. This court adopted plaintiff's judicial admissions that violations of state or federal regulations are irrelevant for compensatory or punitive damages, and that's all that's left. And so, Your Honor, if you have any other questions, I'd be happy to answer them, but I think it's entirely important here that we apply the same standard, the same rules, the same holdings to both parties in this case, and that we take the plaintiffs at their word. And I would ask the court to exclude Catherine Hutt because she no longer meets the assistance requirement as an expert, because all of her testimony is predicated on what has already been determined to be irrelevant information. If you have any questions, Your Honor, I'd be happy to answer them.
Not at this time.
Thank you, Your Honor.
Judge, first of all, it's Dr. Hutt. It's not Mrs. Hutt or Miss Hutt, as counsel referred, it's Dr. Hutt. Dr. Hutt, as the court member calls, testified before you twice already. She's a quality assurance expert. True, she was the one that basically wrote these federal regulations. She testified to that and presented that in her qualifications portion. but we have not focused the case on violations of federal regulations. That has not been the focus of the last two cases. That is not the focus of this case. So there's two reasons why this motion should be denied. Let's start with the procedure. The motion to eliminate deadline is long past. Okay, they knew this motion was going to be granted because it's been granted in all four of the trials that we've had so far. So to suggest that they can use the date of entry of the order as some kind of springboard to file an untimely motion is just not well taken. So they should have filed, if they were going to try to exclude an expert, they should have filed a motion to exclude this expert. The motion was the eliminate deadline, which I think is 2 months back. So for that reason, it should be denied. Second of all, this is the fundamental mistake in their entire motion. They say, this is on page 2, lines 22 through 25, they say that the entirety of Dr. Hutt's opinion is that there's been a violation of federal regulations. That is not her opinion, Your Honor. She is not a federal regulation expert. We have never, in any of the trials, including this one, presented this case as a federal reg case. What her opinion is, and these are all going to be on the bullet points I present today. One, her opinion, and same bullet points that were presented in the last trial, the trial before. One is that non-targeted screening before they put the product on the market should have been done. They should know what's in their product. That's her first opinion. Two, after they got these customer complaints, they should have done this testing. That's her second point. Three, that the customer complaint procedure was inadequate, and it was, and she points out. Four, she criticizes the quality control because they don't have a trained quality control director. You know, instead they have a receptionist that's worked as a receptionist for 6 years, and they appoint her as the quality control director for the next 2 years. Even she, Patty Congress, admitted she wasn't qualified. Okay, we don't need a federal reg for that, Your Honor. And then she talks about the finding in the audit report, the NSF audit report, that there's no one here qualified to make safe drinking water. So those are the keys of her opinion, all of which are not an expert FedRec person coming in and saying, oh, here's CFR 6 and they violated it, here's CFR 7, they violated, here's CFR 8, they violated. So what they have done is they're trying to convert these opinions that aren't about federal regulations into federal regulations opinions by running to the CFR and say, oh, well, this one talks about customer complaints, and this one talks about training, and this one talks about that. So because of that, this must be a federal regulation. It is not a federal regulation, Your Honor. And I will admit that Dr. Hutt, her opinions are pretty much the same as the federal regs because she helped write these federal regs. So when she has a position on quality assurance and now it's reflected in the reg she worked on, yeah, it's going to be the same thing. But that doesn't make this into a federal reg case. We're trying not to make it into a federal reg case. And I will admit at points, at times, especially under cross-examination, she's had a tendency to say, well, CFR says this or CFR says that. We'll try to get her not to say that, Your Honor, because I don't want to get federal regs in the case. But truly, that was the defense counsel's urging in the last cases. So for that reason, number one, the motion is not procedurally improper. And number two, their fundamental premise that all Dr. Hutt is a federal reg opinion is wrong, Your Honor. And so for those two reasons, we think that the motion should be denied.
Thank you, sir.
Your Honor, first and foremost, from the procedural issue, this court has entertained multiple motions.
I'm not as concerned about that. And I think I had a general inquiry early on regarding her opinions, because I just don't remember federal regulations. I thought it was more of a quality assurance issue. For example, and I don't remember the exact dollar amount, but a general testing of the water early on before it was put into production. I think, and I
forget the name of the test, but it's my recollection, it's $200 that could have gone and had your product tested with some sort of broadband type results as to specifically what would have been in the water. And hydrazine would have been one of those items discovered.
Correct, Your Honor.
Things like that, and then I think part of it dealt with, I guess I remember her name now since Mr. Kim brought it up, but their quality control individual was basically, and there's nothing wrong with being a secretary, there's nothing wrong with that. But that doesn't mean or stand for the proposition that you can be learned in quality assurance and or quality control of a water bottling facility.
And why can't you, Your Honor? Because it violates HACCP, which is,
Why can't you?
why can't you? That's the question I'm about to answer, Your Honor.
No.
Ms. Hutt's opinion, sorry, please
No,
continue.
wait, no, I understand, go ahead, I just want to make sure I understand.
Sure. So Ms. Hutt's opinion, Your Honor, with regards to the secretary or the quality assurance person or anything else, falls directly under Part 117.4, qualifications of individuals who manufacture, process, pack, or hold food. Section 117.1, personnel under current good manufacturing practices. And derivatively, under her analysis of the food safety plan that she believes should have been in place under Part 117.126 of Title 21, Chapter 1, Subchapter B of the federal regulations. And Your Honor, just so you know,
What, was she deposed in this case?
she was.
Okay, and what did she say?
Her deposition is the same as her trial testimony. She continually cites back to the federal regulations. And to Counselor Kemp's point, there's a reason, Your Honor, that I only used Mr. Kemp's examination in the trial brief. I didn't include cross. This notion that, oh, this was all brought up by real water is simply demonstrably false. If we go to Mr. Kemp's direct of his own witness, and I'm looking at page 54 of the transcript here.
And where are you at? I just want to make sure I got all these.
I understand, Your Honor. It's Exhibit A1. This is the transcript from the Brown litigation. Page 54 is where she discusses the food safety plan, which is so integral to her opinions on everything.
And what page is that on again?
Page 54 of the transcript, Your Honor. And we're starting with line 10 for this particular example, Your Honor. And I'll read it to the record. Question, okay, and you mentioned a food safety plan. What is that? Answer, food safety plan is actually, not my words, it's a regulatory requirement for real water. It comes from the Food Safety Modernization Act regulations, which are based on HACCP, and it's designed for preventative controls, which, Your Honor, as a callback, is a specific subsection of that federal regulation. They are 21 CFR Part 117, which again, Your Honor, is the exact regulation the plaintiffs claimed was irrelevant in their motion limiting 16. Reading further, it describes what you have to have in order to have a food manufacturing facility in the United States. It's regulated by FDA. It starts with having a food safety plan, which starts with a hazard analysis, a comprehensive hazard analysis. And Your Honor, when it comes to the non-targeted testing, again, she refers back to the GCMPs, right? The current good manufacturing practices. And she refers back to the idea that you have to test for known and unknown hazards, which respectfully, Your Honor, I think is somewhat difficult to do when the entire industry has no idea that hydrazine is an issue. But for the purposes of this motion, we can look to, well, we have multiple. The food safety plan, again, CFR Part 117.126. The hazard analysis she testified to, 117.130. Mr. Kemp can avoid saying the federal regulations and telling the jury what specific regulations they are, but that doesn't cure the fact that all of her opinions that will be presented to the jury are entirely included in state and federal regulations that plaintiffs have argued are relevant and that the court has adopted. So Mr. Kemp went through the 6 opinions, Your Honor. These are the opinions that are included in the trial brief. And we went through pains to go specifically through each of these opinions. Cite to the testimony that she provided, cite to the opinions in her report, and then tie those opinions to where she references federal regulations, Your Honor. This testimony is one and the same. You can't split this hair. If this court allows Ms. Hutt to testify, she will testify as to practices that are founded upon compliance with these federal regulations. She wrote them. She lives and breathes them. She recommends these compliance with these regulations to other companies. She served as compliance officer for companies. This is her testimony. We can't simply say, oh, well, we're not going to cite the regulation, and that cures the issue, because it's the substance that matters. And this court has determined, in response to motion in limine 16, that the substance of complying or violating, which is important, violating these federal regs or these state statutes is irrelevant to compensatory or punitive damages, which are the only remaining issues in this case. And Your Honor, we have to be consistent here. The court has already determined that the real water defendants are not allowed to talk about other testing, compliance with these particular regulations in other fashion.
Well, I can say it's a matter of law why I did that, because that's not relevant to the issue of a defective product that needs to be dangerous.
But liability's been established, Your Honor.
But that was the basis of my liability decision, right? I mean, at the end of the day, I look at that as a different issue, but go on, listening to you and everything else.
Well, then, Your Honor, I think that we've reached the appropriate conclusion with the trial brief. If liability's been determined and compliance is irrelevant, Ms. Hutt shouldn't
Compliance
testify.
is irrelevant for the purposes of determining a defective product and needs to be dangerous. Because here you're talking about conduct.
But that wasn't what was argued, that wasn't what was decided with regards to motion in limine 16, Your Honor. That's why we provide the transcript. I asked this court, and there's a lot of arguments at that point, Your Honor, and I'm sure you remember it, where the defense argued that the FDA regulations, the conscious disregard standard for punitive damages, the conduct of the parties in attempting to comply with certain regulations, were relevant to the issue of punitive damages, and this court said no. Not as to liability, not as to whether or not there was a defective product. We specifically discussed the issue of whether or not these were relevant or not to the issues of compensatory and punitive damages. Counselor Pepperman got up and said, no, they aren't. Counselor Pepperman got up and said, these are irrelevant. The moving papers from the plaintiffs say the same thing. Violations of federal regulations, such as all of the different regulations that we've talked about today, according to the plaintiffs, are irrelevant to the issues of compensatory and punitive damages. For an expert to testify under the assistance problem, the information that they provide has to be relevant. That's the core determination.
Here's my next question for you. You're saying that the only duties and obligations in this case owed by Real Water to the plaintiffs are based upon those contained in the federal regulations.
That's not what I've argued, Your Honor, not even in the slightest. But what Real Water has argued is that there are factors to be considered when determining whether or not punitive damage should be awarded under the conscious disregard standard.
Right, but I mean, so if there can't be a common law, I mean, what are the common law basis for the, and I understand, and I don't want to go down the road discussing 402A, especially when we talk about common law. I'm talking about as it relates to the conduct under 42.005 and all the, fraud, oppression, malice, expression implied, and/or conscious disregard. And the reason why I ask that, because, I get it as far as the motions filed, but you're saying, look, Judge, you can't let in any standards now, I'm sorry, any evidence regarding your conduct, because I granted motion limiting number 16.
Your Honor, I think the court has taken the trial brief too broadly. That's not what we're arguing.
Okay.
If counsel wants to get up and ask Blaine Jones or any other witness about whether or not non-targeted testing was conducted, and whether it should have been, based on the risk associated with research and development, fine, ask the question. But at the end of the day, providing an expert opinion that not doing non-targeted testing somehow violated a standard or should have been done is what this court has determined is irrelevant. And that's the issue. If we want to talk about what testing was and wasn't done, this was actually the subject of a sidebar with Your Honor in the Brown case. Mr. Kemp, and I'm paraphrasing here, basically said, look, we're interested in limiting the testimony to whether or not testing was done. And this was in relation to this particular motion in limine. And the court decided that the court was not going to allow the introduction as to whether or not that testing complied with these particular federal regulations. And so we're asking for consistency here, Your
No,
Honor.
I understand that, but answer my question. I mean, you're just saying, look, because I want to understand the thrust of your motion.
Sure.
You're saying that, look, anything, any opinion the expert has in this case that somehow touches upon any federal regulation is excluded as a matter of law based upon my prior decisions.
Yes, Your Honor. The purpose of her testimony, and to narrow that slightly, the purpose of her testimony is to provide the 6 opinions that Mr. Kemp gave you today. Those 6 opinions are all rooted in, referenced by, and specifically targeted by these federal regulations. And we're asking the court to reach the same conclusion it did in Brown, the same conclusion that it did
When you
in
say,
this case.
what conclusion did I come to in Brown? Because here's my point. I permitted her to testify regarding lack of initial testing, poor quality control, no quality assurance, and all those factors came in and were ultimately relied upon the jury when they made their determination as to punitive damage.
Because there was no objection at that point in the trial, Your Honor. If we were trial counsel, we would have been doing this in the Brown litigation too, because there does need to be consistency in the rulings. The fact is, right now, we're in a situation where we have to, I struggle with this, Your Honor, because we have an expert that only deals with opinions on 21 CFR 117 and related state regulations. We have lists in 117 of inorganic compounds that are supposed to be tested for. We can't talk about that. We can't talk about the other testing that was done in relation to attempts to comply with the FDA. And we have a ruling of this court that it's not just compliance or attempts to comply that are irrelevant. This court has ruled that violations of these regulations are irrelevant. And that's why I used the verbatim language from Motion in Limine 16 in the trial brief. Because this is what the plaintiffs wanted. This is what the court adopted. This is the law of the case. Violations of federal and state regulations, any opinions tied to whether or not those federal regulations or the standards that are codified therein has been deemed irrelevant to compensatory and punitive damages, Your Honor.
So last but not least, I just want to make sure I understand what your position is. You're saying, look, Judge, the only basis of liability as it pertains to punitive damages in this case, vis-a-vis a conscious disregard, is limited to the federal regulations.
No, Your Honor. My point is that this particular expert witness only testifies in that context, and it's been deemed irrelevant. Your Honor has a lot of decisions to make in this trial about other issues, in that broader scheme of things, but as it pertains to this witness, everything is federally regulated that she talks about. And it's even HACCP in general, Your Honor, she goes into the trial brief. I put this language in there because I think it's very important. She relies on HACCP because she got it into the federal regulations and all of her prior companies followed the standard. When she talks about whether or not there should have been certain things done, she goes back to hazard analysis, relying specifically on a food safety plan. And Your Honor, those are all one entire subsection of 21 CFR 117. So Your Honor, the broader question remains on issue.
And what's the basis for that? I mean, where did it come from as far as all those different regulations?
All those different regulations, Your Honor? I mean, I can't speculate as to why lawmakers decided, or an administrative team decided to enter those regulations. I don't think that that's an issue here, simply because they do exist and they are the basis for her opinions. And this court, as I said, has determined that this is irrelevant. That's the entirety of it, Your Honor. Why they were entered doesn't matter. When they were entered doesn't matter. The fact is, HACCP, compliance with HACCP, compliance with HACCP standards for hazard analysis, preventative controls, corrective action, handling customer complaints, having a qualified individual, which is the phrase she uses, which is a defined term under the federal regulations. All of this is directly arising from whether or not Real Water complied or violated state and federal regulations. And currently, the law of the case in this trial says that that is irrelevant, which violates the very black and white standard for the assistance requirement under Nevada law for allowing an expert to testify at trial. And for that reason, Your Honor, we do believe that based on the law of the case, based on this court's own rationale, she has to be excluded because that's all she testifies about. And we've heard that today from Mr. Kent. We know the opinions in this trial that are coming. They're all addressed in the trial brief, and they all rely on federal regulations, Your Honor. So if Your Honor has any other questions, otherwise I think I've beat this horse to death.
And thank you, sir. And what I'm gonna do, I'm gonna go back pretty much to the Litchfield. That's the September 5th, 2024 case.
I'm sorry, Your Honor?
Litchfield versus,
Yeah, I don't have the exact, well, give me 2 seconds, I'll have.
no, I have the case printed out.
Okay.
I have to go back and do it.
Thank you, Your Honor.
And what time did we say we were gonna start? 12:45?
12:45, Your Honor.
All right.
Thank you, Your Honor.
You see, thank you.
All right, let's go ahead and set forth our appearances and directors. We'll start first with plaintiff and move to the defense.
Your Honor, Will Kemp for plaintiff.
Good afternoon, Your Honor. Teddy Park on behalf of the plaintiff.
Good afternoon, Your Honor. Robert Eglin and Maggie Federico for the plaintiff.
Good morning, or good afternoon, Your Honor, Brianna Sitza.
Good afternoon, Your Honor. Eric Kupperman, the plaintiff.
Fred Johnson, Tyler Watson, Michael Esposito, and Eric Freeman on behalf of the defense, Your Honor.
Good afternoon.
We get counsel?
Counselor Freeman? Yes, Your Honor.
Freeman, yes. Good afternoon. Good afternoon, sir. Anyway, I have a couple of comments. I had a chance to review the Litchfield versus Tuscan Ridge Homeowners Association case. And when I was reviewing it, it's holding, it appears to me, is specifically limited to scenarios where you have a reassignment of a case, and specifically I think it was Judge Crockett denied a motion for summary judgment. Subsequently, Judge Peterson granted a motion for summary judgment. And under those circumstances, the Nevada Supreme Court said the law of the case doctrine applied, except for 3 potential exceptions. And I look at this case here, and there's been no change of the trial court. There's been no change of the judge. I'm the same judge. I've heard this case from start to finish. Consequently, I don't see the application to this case, first and foremost. How am I saying? Secondly, I was digging a little deeper, and I went back and reviewed the underlying motion in limine number 16. And I just have a couple questions in this regard, because it appeared to me the primary issue, or one of the issues involved as far as the motion in limine concerned the potential opinions of expert report of Julian Olson, is that correct? Right? And here's my point. I took a look at her opinions, and it appeared to me that they were based upon the fact that, for example, the United States Food and Drug Administration, Department of Health and Human Services standards for quality of bottled water that do not include hydrazine. Is that correct?
Your Honor, expert Olson has not been named as a witness in this case, nor is she being called.
Okay, the only reason I said that, because she was relied upon in the motion in limine number 16, the opposition, right?
Potentially, Your Honor, but Catherine Hunt is the one referenced in the motion.
No, I understand Catherine Hunt. I'm talking about, because it was my recollection, the underlying motion was filed, part of it dealt specifically with her opinions as to compliance with the state and or federal regulations vis-a-vis they didn't test for hydrogen.
Yes, but Your Honor, granted the motion pursuant to what the plaintiffs presented, not in response to Ms. Olson's opinions to the contrary.
But that was one of the underlying bases for the motion.
Your Honor, you're exactly right. That was the thrust of the motion, was they wanted to say there's no law or regulation that says hydrazine can't be in water. So what we were aiming at precluding was this argument that real water wasn't effective, or that we didn't act with conscious disregard, because there's no law that says hydrazine can't be in water. And that's what we argued was irrelevant and unfairly prejudicial and misleading and confusing. That was the thrust of the motion, not to exclude every mention of a federal regulation that would exist. For example, the FDA core report has the violations of all this federal regulations, that real water that they found. The establishment inspection reports outline all the violations of federal regulations that were found. And Your Honor, that was the basis for the summary judgment on adulterated product, was it's adulterated under the definition of Nevada law and federal statutory law and the federal regulations. So they're overreading motion eliminate number 16 to come up with some gotcha argument here. That I would note that Dr. Hutt has testified in all 4 trials, 2 before this court, 1 in front of Judge Hardy, 1 in front of Judge Kishner. All of them granted the same motion in eliminate 16, and all of them allowed Dr. Hutt to testify. There was never even any question that by our own motion eliminate against defendants, we were precluding our expert from offering her qualified, valid opinions in this case that are relevant. So, Your Honor, as usual, hit the nail on the head.
But it's important to point out that there's a distinction between industry standards of practice and CFRs, or state and local regulations. Big difference there. Right?
Not in this case, Your Honor.
Yes, it is. You might think that, but there's a difference.
Well, according to
Because,
Catherine
for example, HACCP, wasn't that created before the federal regulations?
That came out of NASA's space program in the 60s, Your Honor.
Yeah, that's kind of my point, right? And so the Code of Federal Regulations were based upon HACCP, right?
Yeah, in part, Your Honor, yes.
Okay. That's kind of my point, right? Because when you look at the, and so, go ahead, anything else? Because, I mean, I understand specifically, I had to dig a little deeper, I didn't enjoy my lunch, I had a little trail mix. That's okay, because I wanted to review everything. But I'm gonna make it really straightforward as far as this is concerned, because at the end of the day, and I remember this case very well in this respect, hydrazine should not have been in part of, or shouldn't have been on any level in the water, in this case. That's ultimately what it comes down to. And I did, and I'll say for the record, because I went back and I reviewed, I pulled the motions, and I read everything, and as far as motion limiting 14, which was 16, was concerned. I went back and looked at the report and those types of things, and I noticed the opinions of the expert, Olson, as she went through them on page, I guess, 4 of the report. And I understand specifically what the issues are. As far as the expert's concerned, 2 things. Number 1, I get back to my original statement, there's a distinction between industry standards and practices and any federal and or state regulations. Number 1. Secondly, the motion at issue, and this underlying motion in limine was not filed, that would be utilized down the road as a shield to protect the defense from any allegations or any punitive damages claims in this case. And that's really what it comes down to. And that's kind of how I see it. And at the end of the day, I'm gonna let the expert testify.
Thank you.
He's testified in the prior cases. And there is a clear distinction between industry standards and practice, and state and or federal regulations. There's a difference there. And Asset's a real good example. That was in place before the CFR was even created, and it was relied upon. And ultimately, I think, based upon what I know about this case, having two cases go to a jury, it's all about, and I mentioned this in the earlier session, there was no quality assurance program in place. Pretty much. I mean, we had a receptionist, she was the head of quality control. There were no processes in place. This case isn't based upon the CFRs and or state regulations. It's not. It's all about product safety. There was no systems in place. Whether or not hydrazine would have come under the parameters of compounds required to be analyzed has no relevance. That's how I look at it. Anyway, that's my decision. Where do we go from here?
And we're ready to continue the opening statement, Your Honor.
Get the jury ready. Mr. Kemp gets set up.
I'm set up, Your Honor. I was going to wait till the jury came in. Are they coming from the back?
We'll bring evidence, please.
Oh, okay. Okay, great. I'm good. Thank you. Remember, I'm hot. I'm hot. I'm hot. Who's that? Where do you find these things? Oh, come on, get over there. Get over there.
You're okay with me, brother?
It's so confusion.
You got to file a formal substitution, You can't just jump over. We'll expedite it, but you can't just,
Another person sitting in another guy's seat who's formed it up. It's kind of nasty.
That's okay.
I apologize.
Okay, I hope it doesn't smell. Okay. Not excessively, I should have said. Okay, there we go. You're such a good little scrivener.
All rest of the jury.
Okay.
All right, the parties stipulate that the jury should be heard.
Yes, Your Honor.
We do, Your Honor.
Okay, Mr. Marshall.
Oh, yes, Your Honor.
All right, Mr. Kemp, it's my recollection, you're going to continue with your opening argument. Is that
Yes, thank you, Your Honor. Good afternoon, everybody. Okay. And again, remember, my name is Will Kemp. Okay, where we left off yesterday, we were talking about hydrazine, the rocket fuel that they found in the real water. Remember, I told you they did 3 tests, and if you take a look in your jury notebook, the FDA tests are the second tab. I told you about the concentrate. This is a concentrate vial. So they had 5 gallons of concentrate in this. We're going to get into in a little bit how they made it. This one's empty, or I couldn't pick it up, but this is what the concentrate looked like. Okay. Now, we talked a little bit about the FDA tests, and again, the FDA tested the concentrate. In addition to the FDA test, there was another company that did tests on the retail bottles. This is one of the real water retail bottles. So remember yesterday I told you they sold it in 3 different retail sizes, and then the big one is for home delivery. Okay. So what this company did, and their name was Eurofins, that's why it says Eurofins there. They're a pretty famous testing lab. And so they took retail bottles, tested 7 of them, and they found hydrazine in all 7 of the retail bottles. Okay, and I know that doesn't mean anything now, the 300 and the units there, but again, one of the experts is going to explain this. But the important point is we now have 10 different tests on real water, 3 by the FDA, 7 by Eurofins. Each and every test, they found hydrazine. So let's turn, those are the Eurofins results. Let's turn to the plaintiffs in this case again, because I want to emphasize that some of them were drinking from the retail bottles. Adriana Bordnabe, who Mr. Parker is going to tell you about, was drinking from the retail bottles, and also Lisa King was drinking from the retail bottles, as well as the 5-gallon jugs. So what happened to these people? Doctors found they had acute liver failure. Next, Shane. They all drank real water. FDA found the hydrazine, and Eurofins tested the retail bottles. They found hydrazine. Next, we know hydrazine causes acute liver failure from the toxicity test. And so real water was a toxic product because every single bottle, every single container of real water had hydrazine in it. And we know that the liver failures and injuries, remember there's acute liver failures for some of the plaintiffs, there's just injuries for 2 of the others. Those were all caused by the real water. We know that for 2 reasons. First, the court's already made that determination for you. And second, with regards to the acute liver failure, we're going to call an expert to testify about this. This is Dr. Hudson. He is a hepatologist. I explained yesterday, hepatologist is a doctor that studies the liver. So board certified, he's done hundreds, if not thousands, of liver transplants. He used to be a children's primary, actually he trained at Pittsburgh, which is where all the, that's where liver transplantation started. So he trained at Pittsburgh, then I think he went to children's primary, then he went to West Virginia, and now he's back at children's primary. But anyway, he studied the medical records, and he's going to say that hydrazine caused the acute liver failure in 11 of the plaintiffs. And then he's going to talk about the medical issues involved with acute liver failure. And so based on his testimony, there's no dispute as to what happened here. The 5th, what happened to these people? Real water caused each one of them to have serious liver injury. Now, you're going to have to determine a compensatory amount. I'll get back to that in a minute, just briefly. But one of the other things you're going to have to do is determine yes or no on punitive damages. And again, these are the damages to deter others, right? So there's going to be a verdict form that's given to you. It's going to have a little box like this, and you either check yes or no. So these are the reasons why we submit that you should check yes. Okay. Again, this is real water. I've already shown you the 5-gallon jug and the retail bottle. Now I want to talk a little bit in depth about how they made this water. Okay, and the reason we're exploring the manufacturing process is we have to show you how to do it, how they did it, to explain what they should have done. So we have to show what they actually did to show what they should have done. All right, this is the real water manufacturing process. It's 4 steps. 1, they electrolyze the water. They put massive amounts of electricity in it. If you take a look at your jury notebook, flip it open, the very first exhibit is an electrical generator. Okay, Mr. Kemp, why are you showing this, the electrical generator? That's what they used to put these massive amounts of electricity in. What they did is they ran all the water through these titanium tubes. Okay, this is a titanium tube that they bought specially for this particular process. So what they would do is they would take water and they would just run it, and let gravity pull it through the tube for 8 hours in 2 different runs. 2 different 8 hours runs they're doing that. But while they're doing it, they take the electric generator that you have in the book, and they hooked one prong here, one prong there, so they had positive and electric to it. And you can't see it, but inside this tube, there's what's called a diaphragm. There's a thing that kind of divides it in half. Okay, and the reason they have that is when you put the positive here, positive goes on one side of the diaphragm, negative goes on the other side of the diaphragm. So what they do is, for the first step in the manufacturing process, they drop 300 gallons of water through this. Half goes through the negative side, half goes through the positive side. They throw away the positive, because remember, they want to make alkaline water, negatively charged water. So they keep the 150 gallons that are now negative, and then they run it through again. And that's why it took 8 hours, because as you can see, this tube is small. So if you're putting 300 gallons and then 150 gallons through it, it's going to take a while. But this is the first step. They juice the purified water to separate the alkaline from the acidic. Second step, they juice it again. Okay? So 2 8-hour sessions. All right? Third step. They take what they have. This is the concentrate. After steps 1 or 2, we have concentrate. Okay? And so what we have in here is super highly charged negative water. So what they've done is they've separated the negative from the positive, and the result is this concentrate, supercharged negative water. Okay? So they take the concentrate and then they just mix it with regular water, and then you have this. You have real water. In the last step, they do a measurement to make sure they have enough concentrate there. They measure to see that there's enough negative, they call it ORP. That means oxygen reduction potential. That's not really that critical in this case. But that's the 4-step process. Juice it, mix it, and if you don't have enough negativity in there, add more of the concentrate. Okay. Shane, can I have my picture of titanium tubes? Okay, so these are the actual tubes. They're going to be an exhibit. You'll get to touch them. They're just the titanium tubes that they ran them through. And again, like I said, there's a diaphragm. And so how did they hold the tubes in place during this process? Shane? They had a rack. And so you see how they just stick the tubes in the rack, and then they hook up the electrical charger to it, and then they juice them. This was all done in a room that's called the concentrate room. Okay? This was a secret room. All the employees were not allowed in this room. There was only one employee, the person making the concentrate, that was allowed in this room. There was only one employee that knew how to make the concentrate. And the reason for this is they thought this was some kind of secret, like Coca-Cola's secret formula. They didn't want other employees to know what it is. And the person that made the concentrate, his name is Blaine Jones. He was a vice president of Real Water. We're going to show you some of his testimony on video here in a second. This is just a picture of the electrical generator that I already talked about. Again, it's item number 1 in your book. So Now I've explained the process. So where did the rocket fuel come from? How does the rocket fuel fit into this? We're going to call the world's foremost expert on hydrazine formation. Again, hydrazine is the rocket fuel. This is Dr. Najim. I think he'll be here Wednesday or Thursday. But anyway, he wrote the 2 leading papers in the world on how hydrazine is formed. He's going to explain the 4-part process I just went through with you. You know, juice it, mix it, then measure it. And he's going to explain how the hydrazine was formed during the 2 electrolysis steps. Electrolysis, that's just a bigger word that means the juice I'm telling you about. And then he's going to tell you that there's probably, may have been, 10 times as much as when the FDA did the measurement later. And remember, the FDA measured toxic levels. He thinks there was more at the time of manufacture. So now that we've understand the manufacturing process, this is what they did. Okay, let's point out what we think they should have done and why they're liable for punitive damages. The evidence is going to break down into 5 areas. First area, and I call it bad conduct. On the jury instruction, you'll see conscious disregard. You know, it's just bad conduct. Okay, number 1, they didn't do the non-targeted screening test before the product was brought out to the market. Remember in your book, Exhibit 2, that's the FDA testing. The FDA did the GCMS test. That's the $100 non-targeted screening test that tells you the whole rainbow of what's in your product. You know, test for all the substances. So Real Water, before they brought this product into the market, and think about this, this is a pretty bizarre manufacturing process. I mean, you're exposing water to high voltage electricity for 2 different 8-hour runs. I mean, you know, this is how Dr. Frankenstein made his monster, right? Just massive amounts of electricity. So before they brought it to the market, they didn't do any testing whatsoever. Okay? Then they had poor or non-existent quality assurance. And we're going to talk a lot about quality assurance in this case. Basically, that's just the steps you take to make sure your product has quality in it and maintains quality. Third, they had customer complaints because they started selling the product in 2010. And again, most of the people in the case got injured in the fall of 2020, some were 2018. But prior to that time, prior to 2018, they had some serious complaints. And I'm going to show you 4 or 5 of them in a second. And they didn't investigate them. They did not investigate the complaints. We're going to bring the Director of Quality Assurance. Her name is Patty Converse. She's going to testify by video. She's going to tell you that even though she was the so-called Director of Quality Assurance for Real Water, she didn't get the complaints. They went to the sales department. And what was sales instructed to do? No, they weren't instructed to investigate them. They were instructed, anyone who complains, send them a free case of Real Water. That was the procedure that was used. Okay, so the third point is they knew about these complaints, they didn't investigate. Fourth point, and I'm going to get into this in a little bit of detail. On October 5th, 2020, remember I told you the vice president was the one who made the concentrate, Blaine Jones? He got acute liver failure. The guy that was making the water himself got acute liver failure on October 5th. And at or near that time, within the next 2 weeks, Anthony Randolph, who was the vice president of sales, and during this time period he was an independent contractor, but he was still involved with sales for the big accounts like Costco, he started hearing from his customers a lot of complaints. People were getting sick. So Mr. Randolph went to Blaine Jones and said, you've got to do something. You've got to do a recall. Went to him twice, no recall. So that's the fourth point. The fifth point, and I think Mr. Eggert's going to talk about this a little bit. I'm not going to touch it that much. Well, I'm not going to touch it at all other than this. So on March 21st, 2021, I think it was, FDA, remember I told you the FDA, CDC, and Southern Valley Health District were doing the big investigation. So after they determined that Real Water was the culprit here, They went out to the Real Water plant in Henderson. I think they also went out to the one in Phoenix, but I'm not sure. But anyway, they found 5 critical food safety defects that Mr. Eglet's going to talk to you about. And we submit that any one of these 5 reasons is sufficient to constitute conscious disregard that merits punitive damages. Now let's go back to the first point. They failed to test the product before the sale started. This product was invented by this guy. His name is John Marlowe. He's going to testify by video. Interesting guy. You'll see on the video that I asked him what he knew about chemistry, and he tells me he failed it in college. But so here's what he did. Someone brought these titanium tubes to his attention as a potential way to make water. So he purchased these titanium tubes. And again, these are the titanium tubes he bought. So he purchases these titanium tubes, and he starts tinkering with them. He's trying to make alkaline water because he's going to testify he had a general interest in alkaline water. So he starts tinkering with them, puts chemicals in there, varies the electrical doses, high electricity, low electricity. He does this for months and months. And the way he determined whether or not he was making a good product is he drank it. He drank it. So if it didn't make him sick, it was good. If it made him sick, he changed the formulation. That was the sole testing done. And in the testimony we present, he's going to admit he didn't know. The inventor doesn't know what's in the product. And he's also going to admit that he should have done the GCMS test. Again, that's the non-targeted screening. That's the same thing that FDA did in the Cincinnati laboratory in October 2021. So here's the inventor that's going to admit that before they brought the product onto the market, they should have done this. Next, Shane. Okay, I've shown you this. This is the electrical generator. Again, it's in your package as Exhibit 2. So here are the key testing facts. That's just a picture of a GCMS machine. Next, Shane. So how much would this have cost? I mean, would this have cost a lot of money to do this non-targeted test? No, it would not have cost a lot. $200, some places you get them for $100. $200 to $1,000, hundreds of laboratories across the United States. They actually have one of these machines at UNLV and a number of other places here in the Valley. Okay, so this is what they should have done because you want to see everything that's in the product. You don't want to just test for one thing like bacteria. You want to see everything that's in your product before you sell it. And they didn't do this testing. Next, Shane. Inventor, I already showed you that. He says they should have done it. And then the FDA laboratory, they found it like this when they did the GCMS test in October. Okay, next. So let's go to quality assurance. Again, that's the second point. So we're going to call this woman Dr. Catherine Adams Hutt, Dr. Hutt, and she is a food safety expert. So she worked for the federal government and she developed quality assurance standards for food and beverage products. You're going to hear about something called HACCP, H-A-A-C-P. Okay, that is a hazard analysis and control point program that was developed by NASA, the National Aeronautical and Space Administration, in the 60s to make sure that they were checking all the necessary procedures for building these rockets when they went to the moon. So actually HACCP was developed by NASA way back then. So what happened is Dr. Hutt, building on these NASA standards that turned into HACCP, she helped the federal government develop quality assurance standards. Okay, and she's worked for large companies, McDonald's, they bring her in and they have her implement their quality assurance program. Yummy, I think, is that Yummy or, I always get this wrong. Yum Brands, Coors Brewing, a bunch of others, she'll tell you about it. So she studied the real water manufacturing process and she analyzed the attempts they made at quality assurance. Okay, so she found that there's a complete lack of quality assurance at Real Water. She's going to tell you a little bit about the receptionist. I'm going to get into her testimony later. That's Patty Converse. Well, we're going to have a slide on her. So they hired her to be the receptionist for 6 weeks, and then they needed a quality assurance director. So they made her the quality assurance director. She's the quality assurance director for the next 2.5 years, and we'll get to her specific testimony in a minute. Dr. Hutt's going to talk about a written warning they got in 2018. Inspection agency came in the plant, examined it for a day, and their determination was no one is qualified in this place to make safe drinking water. I mean, how bad can it get? The inspection agency comes in and they say there's no one in this entire plant that knows how to make a safe product. Dr. Hutt's going to tell you about that. Next, Shane. So this is the inspection entity that went in 2018. This is a copy of the actual inspection report that was given from Real Water, and it was required by Costco. Costco, all their suppliers, Costco makes them have an annual inspection. You know, a lot of companies do that. Costco is one of them. So that's the reason there was an annual inspection, because this was done at Costco's insistence. So they did this inspection. There's the date. Can I have the findings, Shane? Okay, remember I talked about HACCP. That's HACCP. So this is the HACCP section of the report. So look at these. Is the HACCP team identified? You know, otherwise, are the people identified who are responsible for making a safe product? No. Is the person responsible have any HACCP training? Again, this is the receptionist. Nope, no training. Do they have a description of the product? No, never had a description of the product at any time. Because like I told you, this concentrate room was secret. Only one person went back there. That was Blaine Jones. No one knew about it, including the quality control director, the receptionist. All right, next. Up-to-date process flow? No. On-site audit? No. Have they identified the hazards? No. I think we have an 8th one there, Shane. 12. No, no, no. So here is the HACCP score. 6.7%. That is an abysmal failure. It's not 50%. It's not even 40%. They're not even in the teens. 6.7%. And they gave this report to Real Water. And as you saw the date, that's January 2018. That's prior to the time that everyone in this case drank Real Water. All right, I talked a little bit about customer complaints. All right, and I think we've gone over that. Next, Shane. So, customer complaints, prior incidences, people that got sick before the people in this case. So again, this is from the Southern Nevada Health District presentation they made in December of 2020 or 2021. These are the common symptoms of acute liver failure. Nausea, vomiting, dizziness, weight loss, vision problems. These are the same symptoms I went over with you yesterday for most of the plaintiffs. Okay, let's take a look now at the customer complaints. Okay, next, Shane. And there's literally dozens of these. I'm not going to go through them all. Let's go to the top 4, Shane. These will all be exhibits. You'll be able to see these if you want. So here's one they got in 2013, an oily red substance inside the bottle. Okay, this is supposed to be pure drinking water. Instead, there's an oily red substance inside the bottle. No investigation. Next one, a strong chemical smell in the bottle. Gee, I wonder what that was, okay? A strong chemical smell in your bottle, and you don't pay $200 to do the GCMS test. Next one, Shane. Gasoline-like substance in the bottle. There's gasoline that they're finding in, this was a retail bottle, I think sold at a Terrible Herbs store over there on Eastern. So they find gasoline-like substance in the bottle. No investigation, no GCMS test. Next one, Shane. Cloudy substance in the water. And there's dozens of these. I just want to show you these 4. Next, Shane. So I told you about Patty Converse. Okay, again, this is the receptionist. She was a receptionist for 6 weeks, and then, so she's the receptionist for 6 weeks, and then they promote her to quality control director because they need someone to be quality control director. So she's quality control director for 27 months. And this is the key time period. Because remember I told you that Mrs. Bordenave and Miss King and Mr. Delmar, they all drank in the first quarter of 2018. So this is the woman in the time period right before that. All right, she had no experience regarding bottled water or quality control, no experience in any kind in food and beverage manufacturing, or even retail experience for that matter. She's going to admit point blank she's not qualified. And then, as I told you, she was told, if anyone complains, just send them free water. Why figure out what happened wrong with the product? Next, Shane. So this is the second real water person that's going to testify. Converse is going to testify. This is Mr. Desitel. He's a veteran that was hired by Real Water in 2017. They told the world that he was the quality assurance director, okay? But they didn't tell him. They didn't tell the guy that was supposed to be the quality assurance director that he was really the quality assurance director. Didn't give him the customer complaints, and he's going to testify. We showed them to him. What would you have done if you had seen these complaints? He would have stopped the production line and done an investigation. He's going to tell you that point blank. Okay. Back to Patty Converse. So they got serious complaints, and I've showed you 4 of them, but this 2018 one, we tracked down the customer that was involved. His name's Watkins. His wife wrote Real Water an email saying that he was in the hospital here in Las Vegas for a week, and the doctor said it was caused by their water. And we're going to show you the email, and we're going to show you Real Water. There's a chain going back and forth, and he's going to testify, okay? No investigation whatsoever. No investigation whatsoever. And the production manager, production manager, again, that's Mr. Desitel. He was told, and he's going to testify to this, he was instructed by the ownership of the company, do not stop the production line for any reason. Don't stop it for any reason. Next. Okay, we're back to Dr. Hutt. We talked about the GCMS testing. They should have done it before sales. Pretty common in the industry to do this kind of testing. She's going to say they should have done it after they got the complaints. She's going to talk a little bit about what the FDA found and what Real Water would have found. Next, Shane. So this is the product recall I just touched on briefly. This is Blaine Jones. He's going to testify by video. He was the guy that made the concentrate. Son of the owner. He was in charge of overall production for almost a decade. He made the concentrate, and again, this is the concentrate. Remember, this is the stuff that you juice, and this is what you get. So he made the concentrate in that little secret concentrate room for over a decade. He, karma, right? He got acute liver failure himself on October 5th, 2020. October 5th, 2020. And we're going to play a little bit of his symptomology during the trial, so there's no doubt whatsoever that he had acute liver failure. Go ahead. So anyway, they checked you into the hospital, right? Yep. And you say, I was diagnosed as critical and rushed into the ICU. That would be the intensive care unit? Yep. So they checked you into intensive care? Yep. Acute liver failure. He's here in a Las Vegas, first he was in a Utah hospital, but then they brought him back here. In intensive care. Told him he had acute liver failure. October 5th. Let's go forward 10 days. October 15th. This is a written response they made to a question posed to them by the FDA. Okay, and this is going to be an exhibit. They got so many complaints during this time period that they assigned one employee, and the date's right here, October 15th, they assigned one employee to respond to all these calls, 25 to 30 calls. That's in addition to Mr. Jones. Okay, next, Shane. So here's the timeline. October 5th, that's when he's hospitalized. October 15th, we got all the complaints. October 25th, GoFundMe. That's how we found out about this. Mr. Jones posted a GoFundMe, and he tells the whole story about himself getting sick there. That's going to be exhibit in the case. Okay, so he posts the GoFundMe. Then they have the meeting on the voluntary recall. I told you about Mr. Randolph, the vice president of sales, comes in twice. He's begging him to do a recall. No, they refuse. So we have no customer recall in October, none in November, none in December, none in January, none in February, and then finally in the middle of March of 2021, we have a recall. Okay, why is that important? Okay, next. These are the dates that 10 of the people in this case got injured. Okay, remember October 15th, that's 10 days after Mr. Jones has his acute liver failure, and that's the same date that they're having 20 or 30 complaints, and they have to assign a special guy. So let's use October 15th as the start date. Nicole, 11/11. Nigel, 11/18. Vanya Diaz, November 13th. Ginger, November 18th. Carrie, November 14th. Glenn Morris, October 29th. Cheryl, November 16th. Abraham, the 15-year-old, November 6th. Carolyn Strong and Gassias, December 1st. All of these are a month and a half after that October 15th date. Okay? None of these people needed to be heard if they had just done a timely recall. So I told you about Mr. Randolph. This is a picture of Mr. Randolph. Again, he's formerly the vice president of sales, then he became an independent contractor in 2020. So he learned from the customers he was servicing like Costco that there were a lot of complaints. And he went to the Real Water offices 2 times, not just once. He went 2 different days and he pleaded with them to start a recall, because it wasn't just his retail customers that were forwarding complaints. He knew 2 people personally that were drinking the water that got sick. And this is directly from his testimony. This is what he told them. It has to be the water. And they refused to do a recall. Refused. So like I said before, no recall during any of these 5 months. And we think that is particularly outrageous because here's October 15th. Shane, next. Like I've already told you, 10 plaintiffs after that time. And not just these 10 after that time. Remember I told you about those 5 babies that flew to Salt Lake? They're all out after October 15th too. There's dozens of people in addition to those 5 and our plaintiffs that got sick after October 15th. Didn't have to happen. I told you the FDA found some critical food safety violations. Mr. Eglert's going to talk about that. Okay, I'm not going to talk about that. He's probably going to go through part of this list with you. So let me just finish with damages, because we're going to talk about this. First, we're going to let the plaintiffs explain their injury. We're going to let Dr. Hudson come on and talk about the severity. I'm bringing a pathologist on to discuss liver slides with you, and then we're going to talk about damages. Okay, so I've already told you that about these liver function tests, okay, the 78 to 27, everybody's got off the wall, off the board, super high, however you want to say it, elevated liver function tests. These are all the plaintiffs. Okay, look at these numbers. 2,900 when normal's 2,700, 3,300 when normal's 78. The ammonia, normal's 32, and they've got 135, and again, that causes the encephalopathy, the brain dysfunction. So at the end of the case, we're going to explain the damages in terms of the permanent liver injury. Next, Shane. So one of the things you're going to hear a lot about is something that's called the Burke paper, B-E-R-K. So you see the lead author is Corey Burke. That's a hepatologist from Stanford University, Loma Linda. So you're going to hear the Burke paper. The Burke paper is actually going to be an exhibit in this case. You can look at it. So what happened is Loma Linda has a branch here in southern Nevada, and they saw 4 people that got sick from real water. None of them in this case, but 4 people that got sick from real water. So they biopsied them all. They stuck the needle in that has the little claw in the end, pulled out some of their liver, and they looked at slides, and here's what they found. Shank? Okay, skip that. Let's see the slides. Okay, here are the slides. Remember I said before blue is bad. So blue is an indication of permanent scarring. So you will see that they had blue on these slides, and that is an indication of, you're going to hear the term fibrosis, and they grade that on a scale 1 through 4. 4 is the worst, and if it's 4, it's cirrhosis, irreversible permanent liver scarring. 1, 2, 3, they claim they can reverse 3. I'm not a buyer on that, but anyway, so when you see blue, you have a permanent liver injury here, okay, and that's what the conclusion is from the paper. Now, you can't just give liver biopsies to everybody willy-nilly. Okay, doctors don't like doing it because it's a dangerous operation. It's extremely painful. Like I said, you don't get any anesthetic. They just stick the needle in and pull out some tissue. So, but 4 of the plaintiffs in this case did have liver biopsies. Adriana Bordnave, Lisa King, Vanya Diaz, and Carolyn Strong. Okay, next, Shane. This is from Vanya Diaz's. Okay, now this is in your book. I think it's exhibit number 4. It's either tab 3 or 4. Okay. So this is the actual tissue slide for Vanya, who probably testified, if I had to guess, I'd say Thursday. So you see the blue here? That is permanent scarring, okay? Permanent scarring. And we're going to have a doctor testify about that. Next, Shane. And his name is Datnow, D-A-T-N-O-W. Board certified. He's going to explain this procedure where you look at the tissue slides, what you look for when you're finding something called bridging fibrosis or cirrhosis. Bridging fibrosis is a permanent liver injury that they look for, and cirrhosis is the end result that you have stage 4 liver injury. So he looked at the slides from the Morales baby. The Morales baby was one of the 5 kids who went up to Utah. So he looked at the slides, those, and he's going to explain that slide shows something called a cirrhotic nodule. Okay, remember yesterday I told you a little bit about regenerative nodules? Okay, so we have the Morales baby, and here's the reason that's important, okay? So the Morales baby was, I think, 11 months old at the time. So there's no other possible explanation for the Morales baby to have permanent liver injury at that age other than real water, okay? They can't say that the Morales baby was a binge drinker. They can't come up with any other potential cause. So we start with that as a baseline. This is what we found in the Morales baby. So he's going to compare the Morales slide with Vanya's slide, the blue one I just showed you a minute ago. It's basically the same thing. You have bridging fibrosis and regenerative nodules, cirrhosis, okay? And then he's going to discuss the pathology findings from a number of other real water victims, including the 4 in the Burke article that I already showed you. Next, Shane. And then we're going to have Dr. Hudson give his opinion on all these plaintiffs and explain what happens when you have permanent liver injury like this. Again, he's board certified. He looked at he looked at 11 of them, all the ones that got acute liver failure. He's going to talk about how hydrazine causes the permanent injury. He kind of picks up where Dr. Kosnet leaves off with the toxicity studies. He's going to talk about the bridging fibrosis, cirrhosis, the consequences, and what's going to happen to these people in the future, in his opinion. All right. Again, that's Vanya's slide. You can't get away from that, ladies and gentlemen. There it is. Blue. Bluer than blue. Permanent liver injury. You cannot get away from that. So at the end of the case, we're going to ask you to give compensatory damage awards to the plaintiffs, and we're going to suggest amounts to you, but we're not doing it now, okay? We're going to do it at the end of the case, after you hear their testimony, because you'll understand where we're coming from better, I think, when you hear what these people have gone through and what they're going to go through. Next. So just the key points here. No question about it. Every single bottle of real water had hydrazine in it, the rocket fuel. Like I told you, 10 samples tested, 3 by the FDA, 7 by Eurofins. Each and every sample, they found the rocket fuel. And there had to be rocket fuel because it was formed, the hydrazine was formed during the concentrate making process. And they used the concentrate to make each and every bottle. So if the rocket fuel's in the concentrate, it's everywhere. No question that hydrazine causes acute liver failure. Next, Shane. All the plaintiffs had serious injury. We have 7 acute liver failure cases. Another serious liver injury case, another one, gaseous, that I don't think I would describe moderately serious, I would say. Okay, next, 4 of the plaintiffs had biopsies. I showed you that. We're going to talk about that. And if you have acute liver injury and it doesn't improve, this is the only treatment option, a liver transplant. And Mr. Eggett's going to talk to you about that in conjunction with Lisa King. And it's a very difficult procedure. It's a dangerous procedure, but he's going to talk to you about that. So everyone improved when they were in the hospital. Their liver function tests went down, and some of them are normal or just above normal. But that is not definitive, because both of the hepatologists that testify, they're going to tell you, you can have normal ALT and AST after an event like this, normal liver function tests, and you still have cirrhosis. You still have permanent injury. The body just figured out a way to compensate. Okay, so thank you very much, ladies and gentlemen. Thank you for your attention. I'm sorry I kind of talked fast, but I was trying to make up a little ground here. Thank you again.
Here you go, John.
All right, ladies and gentlemen, we're going to break in the next way we can prepare and move into that. We'll take about 10 minutes. Anyway, remember, you're admonished not to converse amongst yourselves with anyone else or any subject making to the trial, or to read, watch, listen to the report, or to comment during the trial by any person connected to this case, or by any meaning of information, including without limitations, no such meaning. Last but not least, and that's only expressed any opinion on any subject connected to the trial, you cause prejudice to the
All rights departure.